皆さん、こんにちは。ようこそへ。今度、英語でだけ、喋れています。喋っています。Um, today, this is a very special seminar. This is the May 2023 Obviousness Update. So I have to give you the background for why we're doing this. In addition to public videos, the Modal YouTube channel has many unlisted videos for clients, for seminar participants, and for friends. And there is one specific minute of one unlisted video from May 2023 that continues to attract attention. Uh, it got some hits in like May of this year. This is 2026. And I was shocked and I wrote the seminar, but I didn't quite finish it. And today is August 3rd, and it just got like a hit in the last day or two. These videos are accessible to anyone with the video URL. I don't know who is hitting this video, okay? Maybe it's one person reviewing this one particular minute. Maybe it's being shared among friends or something, um, which is fine. It's a very low level of virality. But the point is I can't tell. I have no, my other unlisted videos don't get many hits, but someone is really interested in this 1 minute. And so and they still don't, they seem to be struggling with it, right? So that's what this seminar is for whoever is still watching that 1 minute. So the context for what we'll be discussing is that the seminar had been discussing how to argue claims in an obviousness rejection. And you'll see that we sometimes use blue instead of black during this seminar for the text color. The blue is from the original seminar. The black is what we're adding today uh, to kind of clarify what's going on. Okay. So because I can't speak directly to the person, right? So first, we're going to find. So again, the two-step process for arguing is that first we're going to find the technical or innovative feature in the application, not in the claim. Okay. I don't mean the advantage. I mean the technical differences. How you had to modify the prior art, for example, the technical differences that produce the advantage, right? What about the device, for example, did you change to produce this technical effect? Second, we're going to consider whether and how the claim reasonably recites only that feature or something different, right? Why is there this distinction, Brian? Well, is that innovative feature in claim one, or is it actually in dependent claim two or claim eight? It's very common that that actually happens, especially from non-US origin cases like Japanese cases. ちょっとうるさいね. This is an Airbnb in Kobe, and the road is right outside. The major road is right outside the house. Is the innovative feature recited broadly, such that the examiner must read the specification to understand it, right? Again, very common that the claim would recite a feature broadly in a non-US jurisdiction. In the US, we need it to be in the actual claim. Or is the innovative feature recited narrowly such that the claim can be understood without consulting the specification? That's what we want in the United States. All right, having said that, this next slide is the slide that keeps getting reviewed by whoever, because I don't know. It's difficult to assess claim scope without considering alternatives like differences or missing features in the claim language. Like when I'm looking at a claim, I'm trying to think about what are, what are is this part of the specification recited the exact same way in the claim, or is it different? Are there features that are missing in the claim language? And the reason I'm doing that is that it's easier to find something if you look for it. And so when I'm doing this, I'm thinking about like, oh, there is something extra, like if I get instructions from a foreign associate, the Japanese Benrishi, is there something extra in our technical argument that is not yet in our claim? Or differently, there is a claim interpretation that does not support the argument provided by the applicant. So let's talk about this a little bit more. There is something extra, for example, an extra feature in our technical argument that is not in our claim. For example, maybe you are relying on the specification for a feature that is not actually recited in the claim or is only recited very broadly in the claim. It is to be expected that Benrishi and European patent attorneys and Chinese attorneys would rely on the specification this way. Okay? That's consistent with these non-US laws. The United States is different. The significance is that because the feature is not a claim element, the claim covers both our implementation and the examiner's proposed combination of art, right? You're correct that, that the examiner's combination doesn't teach this feature, but this feature also is not in the claim at that level of detail. And therefore, maybe the claim can be narrowed to recite that extra feature and to thereby exclude the examiner's proposed combination. The second one is this idea that a claim interpretation might exist that does not support the argument provided by the Benrishi or the applicant, right? You could be 100% correct about a claim interpretation that supports your argument. You probably are, that you're a professional. But the examiner has a different claim interpretation that does not support your argument. The examiner is viewing the claim differently. And therefore, the claim's two interpretations might cover both our implementation and the examiner's proposed combination of art. And therefore, maybe the claim can be narrowed to exclude the examiner's proposed interpretation. This idea is slightly different than the previous slide, right? On the previous slide, the claim was broad because it did not recite an element. On this slide, an existing claim element is covering our invention and the examiner's proposed combination. That's why it's broad. It's a slightly different view of breadth. On the previous slide, I said how um, non-US attorneys frequently run into this issue of something extra in the technical arguments. It's the reverse here. The non-supportive interpretation is slightly more common when the US attorney chooses claim amendments, right? We can tell whether there's a feature that's in the claim. It's just sometimes we're like, oh, I didn't think about how, the grammar allows for two different interpretations. This is usually where we make mistakes. During this 1 minute, I'm also talking, right? We talked about what's on the slides. Let's talk about what I'm actually saying. And I've edited my um, comment to, kind of make it clearer. I say something like, I don't want you to rationalize to me or the examiner how your claim supports the innovative feature. I want you to consider for yourself why your claim might not support the innovative feature. Okay. It's this sort of critical thinking, this, self uh, analysis that'll really help you level up as Amer person practicing in front of the USPTO. To be clear, I do, before I give you this point, I do want to make clear that some examiners do view patentability differently, and they're very arbitrary and hard to predict. But for a typical examiner, good American patent attorneys estimate that they are successful in assessing patentability about 80% of the time. We still make mistakes. Like I said, sometimes it's like, oh, there's a second interpretation that I didn't consider yet. That's about 20% of the time, something like that. Um, and then there's like an extra 10% of examiners or so that are they just view it very, very differently. And you just have to give them a ton of features and hope that whatever happens in their head gets it allowed. But again, you can expect, for a typical case, it's about 80% of the time. But this language barrier is obviously going to prevent non-native English speakers from reaching 80% effectiveness, right? There's so much nuance to claim language, right? Just like I'll never speak Japanese at a native level. I'm still far away from fluent. Um, but I can reach fluency in my lifetime, but I'll never reach native level in my lifetime. But I think that this issue is more based on familiarity with non-US patent systems, right? You were trained to understand Japanese patent law, or if you're a European practitioner, you understand European practice. Um, and you're going to think that it works the same way in the US, and it just does not. But it's not about language, right? British patent attorneys also struggle with US obviousness rejections. Okay, so it's not just like, oh, well, you can't speak English well, right? The British patent attorneys speak English fine. Um, it's about, the legal and technical background you come from. As your US attorney, I don't want to know how you can rationalize via arguments the presence of the innovative features in the claim, right? I'm on your side. Okay. I believe if you tell me the claim doesn't teach a feature, I'm sorry, if you tell me that the references don't teach a feature, I believe you. You don't have to convince me. And I want to present the best arguments I can on your behalf, right? That's my job. And so then again, this is the quote from like the magic minute in that seminar. I say, I want to know if there's an inescapable conclusion that there's something in your claim that's not in these references. Okay. What I'm trying to say is that if you are instructing me, you send two things. You send a concise quote of the claim features that are not in the reference. And in this case, it's okay to edit the quote a little. For example, with brackets, right? Oh, well, the claim actually says the interface receiving, but we're going to edit it to say receives. Or you can use ellipses, right? There's a whole chunk of the claim that we're going to delete, and we're going to say the first data dot 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 sent to the first computer. It's okay to edit it, but I want it to be as close to the quote as possible, like the identical claim language. That's what I want to see. I don't want to see what you think the claim means. I want to see, you find it in the claim and you show me what it is that I'm supposed to be arguing. And then I also want a technical explanation of why the reference lacks the features, right? Why doesn't, why isn't that feature in the references? And this isn't just me, right? I'm speaking on behalf of all US patent attorneys in that case, right? That's what we want to see in these instructions. I don't want to see what you think is in the claim. I want to see you find it in the claim and tell me where it is in the claim. How does the claim present this feature? But if I must choose between the quote or explanation, right? You guys Ben Rishi have limited time, okay? Clients have limited time. The quote is more important than the explanation. If you give me the quote, I can probably create the technical explanation myself. But it can be very difficult for me to quote the claim if I receive only your technical explanation or if I receive your understanding of what the claim says rather than, you telling me the exact words that are in the claim. Why? Well, it is easy for me to reach an agreeable technical explanation on my own, right? Like I have a technical background. Like I've been reading patent applications for almost, we're coming up on 20 years. But it can be very difficult to reach an agreeable legal understanding of the relevant claim feature, right? I don't interpret the claim the way you do. That's why you hired me. I interpret it more like the examiner. I'm looking for the exact words in the claim because the examiner is looking for the exact words in the claim. If I present one of these arguments that's like, oh, well, we think the claim means this, and I present that to the examiner is going to say, okay, but that's not in your claim. How do I know the examiner is going to say that? Because when I started learning law practice or patent practice, and I was doing in-person interviews at the USPTO with that kind of instruction, my examiners would literally say, okay, but where is it in the claim? That's how we examine in the United States. So I know now how to interpret the claim like an examiner, but that means that I struggle a little bit to understand how my applicants understand the claim. It's something I've been working on. I think I do a fair enough job now, but that's why I don't need you to explain what's in the claim. I need you to show me the claim because I can present the technical arguments as long as I know where you think it is. But sometimes, to speak frankly, as an American attorney, I can't always tell where my applicants are, what features in the claim um the applicant is arguing because that's not what the claim says, right? I have to think about like, okay, I mean, and I read the specifications. I'm very, a lot of US attorneys don't. I read the specifications. I know about like, reading the claim and then going back into the specification and trying to find it. And I still can't do it 100% of the time. Maybe there's a translation situation. Maybe at the Ben Rishi firm, someone wrote the claims one person wrote the claims and a different person wrote the specification. And so the wording is slightly different. Maybe at the translation company, one person translated the claims, one person translated the specification. Maybe there was some other issue during prosecution where the claims got adapted and now that it uses different words. There's so many reasons that we wouldn't be able to track what is in the claim versus what my applicant is saying the claim means. And so if you tell me what the claim means, I can't necessarily find it in the claim. I I can't. I don't interpret the claim the same way you do. So I need you to kind of take that step and tell me, you know, let's go back a slide. I want a concise quote of the claim features that are not in the reference. I can present the arguments then. And again, if you give me an explanation, that helps too. But it's the quote. I need the quote. And that concludes it. Happy to take your questions. Um, this was just a quick little seminar. I hope my viewer, whoever you are, or however many people are doing it, I hope this is helpful for you. Thank you very much.